I am Khumo Motse. I was engaged in this matter to represent the government and its agencies in respect of the proceedings that had been brought by the applicant, MOTSEPE. It was a defamation suit in terms of which she was seeking damages to the tune of about 20 million. So having considered the papers and having taken instructions, because you'll remember that when these proceedings commenced, the regime was a different one. So obviously there has to be a distinction in terms of policy. There's been a shift because the orientation, this one is a human rights centric approach. And the human rights centric approach is one that requires that where there has been a violation of rights, individual rights, particularly by apparatus of government, as happened in this instance, then the proper route would be for the government to do all in its powers to try and assuage the wounded feelings of those aggrieved. So it is for that reason that we then took a decision that the proper course would not be to fight the proceedings, because we realized that a wrong had been committed against this individual, and it was therefore prudent to bring the proceedings to an end in the manner that we did. The settlement, as you have noted, is in respect of the costs that have been incurred, both legal costs and what they classify as incidental expenses. These incidental expenses arose in the course of the proceedings, where she sought to engage resources for vindication of her name. So our liability in terms of the settlement extends to the settlement of the legal costs, that is the cost of counsel and those incidental expenses. So the only thing outstanding is quantification of the quantum of those expenses. There is a procedure that is available to determine and get a figure in respect of the quantum of costs. We'll either agree on the costs. In the event of no agreement, we'll subject the legal costs to taxation. So the only matter that now remains pending for determination by the court is the question of the incidental expenses. We'll engage in discussions. We'll try by all means to close this matter by way of settlement, as we have done in respect of the main claim. But in the event we are not able to find each other, then we leave it to the court to make a determination in respect of that outstanding question.
Have you agreed on the date? I understand July was put up as a date for the next meeting following the engagement in the contest.
We'll be appearing before court for status update on the 20th of August. Meanwhile, the parties will then be conferring to try and reach a settlement agreement before that date. If we are not able to reach an agreement, as I've indicated, then we'll get a date where the court will assist the parties to resolve that question.